Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can you do probate without a lawyer? The short answer is yes, it is legally possible in the United States, but the much more important answer is that it depends heavily on your specific situation. Probate is the official court-supervised process of validating a will, paying off a deceased person's debts, and distributing their remaining assets to the rightful heirs. Handling this process yourself, often called pro se probate, can save you thousands in legal fees, but it also means you are taking on a significant amount of work and legal responsibility. You might be able to handle probate on your own if the circumstances are very straightforward. For instance, if the estate is considered a small estate under your state's law, you can often use a simplified procedure that avoids the full, formal probate process. This is also more manageable if the assets are simple, like a single bank account, a car, and a home with a clear title, and there are no complicated business interests or investments. A huge factor is family harmony. If all the beneficiaries named in the will get along, agree on everything, and there are no disputes, your path will be much smoother. A clear, valid, and uncontested will is almost a necessity for a successful DIY probate. Finally, if the deceased had enough assets to easily cover all their debts and lived and owned property in only one state, you've cleared some of the biggest hurdles. However, there are major red flags that should make you hire an attorney immediately. First and foremost, any family conflict. If beneficiaries are fighting, if someone is threatening to challenge the will, or if there's a disgruntled heir, you need a lawyer to navigate the dispute. Second, complex assets are a major complication. If the estate includes a business, commercial real estate, or extensive investments, you need professional guidance. If there is no will at all, the estate is considered intestate, and the court will have to follow strict state laws to determine who gets what, a process that is much more difficult to handle alone. Other absolute hire a lawyer situations include an estate that owes more money than it has, meaning you'll have to negotiate with creditors, or if the deceased owned property in more than one state, which requires a separate probate process called ancillary probate in the other state. Remember, as the estate's executor or personal representative, you are a fiduciary, which means you have a legal duty to act in the best interests of the estate and its beneficiaries. This involves a lot of specific tasks: filing the will with the correct court, formally notifying all heirs and creditors, creating a detailed inventory of all assets, paying final bills and taxes, and then distributing the remaining property according to the will or state law. If you make a mistake, you could be held personally liable for any financial damages. Ultimately, deciding to do probate without a lawyer is a calculation of cost versus risk. For the simplest, smallest, and most harmonious of situations, it can be a perfectly fine way to save money. For anything even slightly complicated, the cost of a lawyer is often a wise investment for peace of mind and to ensure the process is handled correctly and efficiently during an already difficult time. Thank you so much for watching. We hope this information was helpful. If you found value in this video, please give it a thumbs up and consider subscribing to our channel for more content on managing financial and legal matters. We'll see you in the next one.